I mean, I'm so lucky today because I'm here with two of my best friends in the world, and I have known them for many, many years. When I say many, many, you can tell it's a lot, right? But I have with me today, helping me because I can't do this alone, Rose Jones from Hilgers. She's an e-discovery, proud partner in e-discovery counsel for Hilgers, and somebody that I respect so much. And she's going to help me ask questions of my other friend, Paul Grimm. Paul Grimm probably doesn't need an introduction because all of you know that he was a magistrate judge in the District of Maryland, and then federal district judge of District of Maryland, and has written some of the deepest and best opinions on e-discovery and on evidence and on the rules that you could ever find. When I talk to him, I'm just always amazed, and I think you will be as well as we go through this topic today on AI. You notice that we're kind of in uniform today. I thought that I'd come in here and sort of eschew my Florida tie. I feel kind of naked down here, actually, and put on this and rock the bow tie like Paul. But I looked in the mirror this morning, and I think I look more like Bill Nye the Science Guy. Yeah. But it's not without trying, you know. So I know that that you're all anxious to get into our topic about some of the problems that we have with AI. Yesterday was such a brilliant day for this conference, starting with the keynote and then progressing through a series of sessions that raised some very important issues about AI, including hallucinations, and then including also some of the difficult evidentiary issues that we're going to be facing with AI. And they were very well covered yesterday, and today we're going to take a deeper dive on two of those issues, which are the hallucinations and the introduction of evidence. Judge Grimm, welcome to the Florida conference.
Thank you very much, Ralph.
We're just so fortunate to have you here. But you and I have been involved with e-discovery and with technology for more than 25 years. And we witnessed the transformation of litigation from paper to digital evidence, and also the tremendous procedural and ethical challenges that followed. Now with this new wave of artificial intelligence, it seems like our industry's under siege again. And so we need some help getting through this. You've been a national leader in developing and interpreting the federal rules of civil procedure. You've been on the committees that developed the rules. We worked together in 2006 with the Sedona Conference, making changes that made e-discovery better. Then 2015. And you've been very active with these new potential AI evidentiary rules. And our focus today are going to be those two urgent topics of AI-generated evidence and then hallucinations and other pitfalls. So I want to start with the AI-generated evidence, but I'm going to turn it over to Rose to ask the question.
Thank you, Judge Artigliere. So I'm not only going to say good morning, because as Professor Hamilton mentioned, we are being joined by attendees all over the globe. So good morning, good afternoon, and good evening. Yeah. What an honor to be here. And I am so grateful that the world is watching, because this is a global issue and this is something that we all are dealing with. And so we're going to start out with generative AI and deepfakes, and how generative AI can alter metadata, it can alter media, and it's very challenging because it does a really great job. It's only going to get better. So Judge Grimm, what are the practical steps from your perspective that the court and the bar can take in order to deal with these types of issues?
So I want to take just a second and just focus everyone on just how recently this issue has popped up. And I think we need to all give ourselves a little bit of credit for the fact that with all the interest on this, you would think that this was, this was on Blackstone's lips when he ceased to breathe, was artificial intelligence. But while AI has been around, AI is nothing more than algorithmic codes being used to address data in a way that they've been programmed to create a sequential analysis of a problem they've been trying to deal with. And AI has been around since the 1950s in the famous Dartmouth. It's generative AI. Gen AI is the thing that we're wrestling with. And I've been writing and looking at the evidentiary implications of technical evidence for a lot of years. And I remember distinctly in 2022, when ChatGPT came out, hearing what in the world is generative AI. I had no idea what generative AI is. So it's now 2026. So we really haven't had this for that long to be dealing with it as a phenomenon. But look at how it's changed in just that period of time. And we're dealing now with technology that has a profound ability to impact because it can be used to present information in a way that is enormously persuasive, whether it's visual, whether it's written, whether it's audio, music. It has the ability to create in a fashion that is increasingly realistic and hard to distinguish from something that was actually made and created by a human. So the old issues where you had like 6 fingers on a hand that would be a tell, or the shadows didn't line up, or there was a picture right here, but there was a stop sign behind and the stop sign was spelled SQRZ. And so you could see that there were things that were wrong. Those are gone now. So this is technology that has come here very quickly. The other thing we need to realize is that the tools that we use to develop how we use this in the resolution of disputes. Now, this is a crowd that understands everything that goes up to trial, the pretrial discovery, because that's the case. In civil cases, of course, so few cases go to trial. There really is the pretrial phrase. And we did a pretty good job when we were overwhelmed in 1999 and 2000 with digital information. But we had almost 15 years to get that right. Here, we've been playing in this orchard for 3 years. And it feels like it's changing so fast that the moment we start to understand one aspect of it, it changes again. And the rules of evidence, just like the rules of practice and procedure, the rules of evidence are generally technology agnostic. They don't specify one type of technology or another, just because by the time you get a rule through the process, it's 5 years or more. And so by the time you have a rule to deal with the technology may have changed or even disappeared. The other thing, too, is that in our system, while we have many countries in the world that, like our country, originated from the British system, the common law system, we exalt the jury trial in our country above all other countries. We have more jury trials in civil and criminal cases than any other country in the world that has jury trials recognized. In Great Britain, most of the civil cases are not tried by a jury. Some are, but not all. Criminal cases, it's a different matter. So we have these rules that are general tools that apply well for most of the things that people are well acquainted with through their own perception. And now we have to try to deal with this technology that has an aspect where it's just hard to explain. So take a moment to look at the rule that's the most complicated, the most focused on scientific, technical, or specialized information, which is Rule 702, experts. Well, we can talk about error rate and peer review and whether the methodology has been accepted. But with a lot of these generative AI tools, you can explain how it was trained and you can explain how it was tested. But when you are actually trying to figure out from this query, how did it get to this answer, then the ability to explain kind of drops off. And that's what we're wrestling with. We're also wrestling with it because the tools that we use for this kind of evidence generally speaking, it's non-testimonial evidence. Now, that's a hard thing to do because our generative AI is talking to us. Well, Paul, that's a great question. It compliments me for being so brilliant as to ask, what's the nearest metro station to this address I have to go? That's a great question, Paul. People are asking that all over the world. And so I say, wow, boy, I'm pretty smart. I want to know where that metro station is. And, so it's trained to try to react to us as a human being. It sounds like it's talking to us, the Oracle of Delphi. But it's non-testimonial evidence because they're not humans. And the rule that we deal with that is authentication. Does it do what it's supposed to do? And as we heard yesterday, Bill, and everyone else, one of our judges said, he's right here with us right now, said, it's a low threshold. I'm there. It's more likely than not, preponderance, 51%. That's slightly better than a coin toss. Does it do what it purports to do? And so a lot of stuff is better than a coin toss, but not great. And we have to then start focusing on what is this technology doing and what's the risk if we get it wrong? Because remember back in the old ESI days, we would say, oh my God, it's got 80% recall and precision. Well, compared to the next alternative, which was a human that was at 55%, it was pretty good unless you were deciding an issue that if you got it wrong was going to destroy the world. And then you have to have a greater amount of ability to be able to demand more precision. And the rules of evidence require that when you have contested issues on whether or not evidence is relevant, the jury is the one to decide these things, not the judge. The judge is your preliminary gatekeeper under Rule 104. All right, and they can decide admissibility of evidence, qualification of witnesses, and the existence of a privilege. But if you have something that we're going to see with generative AI, which is, was this defamatory post that was online, that's now the basis of a defamation case, created by a person who's being sued to be held responsible, or a bot? And it's so good that the person who wrote a derogatory review of something and has written 1,000 reviews, the bot can go look at all those, capture the language, the style, the slang, the essence of it, and write it that way. And one side says, this was done by them, and how do you know that? Well, look at all the similarities with all the other things they've done. That is comparison of a known sample to an unknown sample, right? That's, that is a recognized method of authentication. Someone else comes in and says, no, I didn't do it. It wasn't me. I honestly didn't do it. You can go through my computer. You can look for it. It's not there. That dispute is, the evidence is not relevant to show defamation unless you show that the person that issued it or authorized it was the one responsible. So you have some evidence that shows it could be a real defamatory statement, some evidence to show that it was fabricated. The judge says a jury could go either way. The jury gets to see it. And now what are they exposed to? They're exposed to the very statement, which may not be authentic itself, so powerful and so persuasive, because you're not going to use this stuff for the mundane evidence that's well corroborated. This is going to be the knockout stuff. This is the opening statement clip that you want to show the jury. And that's the challenge that we have, because in that instance, the jury is exposed to the potentially fabricated, hallucinated evidence, because they're the ones that have to decide whether or not it was attributed to the person who is responsible for it, being held responsible in the suit or not. And then we judges say, in that cavalier way, ladies and gentlemen of the jury, you've heard, seen this videotape, and you've heard of evidence that is generated by a computer and not by the defendant. If that's what you find, then disregard it and give it no effect whatsoever. Well, we don't lobotomize the jury now, and they can't remember it, so they have seen it. How do you unring that bell? That's what the evidentiary rules struggle with now. And we heard about some of those, and we may be able to be talking about some of those, but I don't think that any of the ones that have come out yet have adequately looked at that issue in a way that would be helpful to all of us here and all the judges who are working 7-day weeks with overwhelming caseloads to try and have the tools necessary to get it as right as we can, so that the integrity of our fact-finding process, which is the jury deciding or the judge deciding, is not compromised by our inability to know whether something is real or whether it's not real.
Okay, well, let's talk practically then about how this would arise in a case. I mean, you have either disclosed or undisclosed alterations, whether it's a photograph or whether it's a video or whether it's a, as you were talking about, language like that. So tell how this would arise in the case, and then step by step how the judge would deal with it.
All right. So what I want to sort of sketch out is if I were the king of evidence, and I volunteered many times, but they have not taken me up. Then there are two rules that we could do right now, I think, that would really help us. One rule is an acceptable way to authenticate what is acknowledged to be artificially intelligence generated information. Just a way that says, if you're offering this and everybody agrees that this is what it is, this is a sufficient way to do it. Now, all the authentication rules in Rule 901, 902 are just illustrative. They're not the universe of it. So if you do it this way, that's enough. Because then the good lawyers will follow that. Lawyers who try and cut corners can be held accountable to it, and it's the standard the judges can apply. And we could talk about the details of what that rule would look like. My co-author, Judge or Professor Maura Grossman and I have submitted that, and the Evidence Rules Committee decided that that was not a direction that they wanted to consider at this time. They have other rules. The other one is unacknowledged generated AI. And I'll give you a very simple example. So Ralph was saying that we've known each other for a lot of years. I've talked to Ralph on the phone. I've been on videos and Zooms with him. I've been in programs with him. He knows my voice. So let's say he wakes up one day and there is this extortionate email, a voicemail on his phone. Ralph, if you don't deposit $12.16 of Bitcoins into my account, I will tell the world that when we were at the University of Florida, those bow ties were pre-tied and we couldn't do it. And your reputation in the legal community will be ruined. You have until noon to comply with this, and to think I once called you my friend. He's shocked. He's shocked. He says, my God, I was just with this guy. I know what he sounds like. Rule 901B5, opinion as to voice. That is, there's not a judge in the United States that would not say, if Ralph testified under those circumstances, I know this, and this is what it was, that would not say that's sufficient for a jury to find it's me. I come in, and I say, Ralph, I'm wounded to the core. I love you like a brother. I would never do that to you. Yeah, they were pre-tied bow ties, but that's not felony. That's misdemeanor, if anything. We're not worried about that. I would never do that. And besides that, I don't even know what a Bitcoin is, let alone how to do something with it if I had it in my account. And if I'm going to extort someone, it's going to be a lot more than $12.50. I can tell you that. So I didn't do that. Well, if I come in and deny it, and you're the judge, and you've heard the tape, and you've heard Ralph say that, and you've heard the very voice deny that it was me that you heard on that recording, then you might be willing to say, well, how do I know? It sounds like your voice to me. I'm going to let it go to the jury. So what would I then have to do to be able to establish that it's a fake before the jury gets to hear that reprehensible recording and be so shocked by it that even if I were on the stand under oath denying it, they would hear my same voice doing it? And how does that come up? Well, the judge should have to have some advance notice that there's going to be a challenge based upon this being fabricated evidence. We now have that. Is it Grimm's voice, in which case it's relevant and the jury can consider it, or is it not? It's irrelevant and it must be disregarded. But we want to try to make that decision so the jury doesn't have to hear it. How does that happen? And the current rules won't let that happen, because under Rule 104B, the jury has to hear my explanation as to why it's not me, your testimony that in your opinion it's me based on your knowledge of my voice, and they have to hear it. And for the judge to say, I'm going to exclude that, the only exclusionary rule is Rule 403. And that's a tough rule because it says that the probative value must be substantially outweighed by the danger of unfair prejudice. But the more probative it is, the more double the prejudice has to be before you can exclude it. Rule 403 tilts towards admissibility. What we need is the ability of the judge to be able to say, you know, this is close. Maybe it is close, but if it's not more probative than it is prejudicial, I'm not going to let it come in. And then you would say, well, what would the judge want to look at? Well, the judge could come back to you, Ralph, and say, you got any other corroboration? So maybe corroboration is that, you know, someone heard me say, you know, Ralph, you know, I was embarrassed to death to have to wear that tie that was a pre-tie bow tie. I'm going to really make him pay for that. And that corroborates that. Or there's other evidence that could show it, or that there's other evidence of my identity is such that if it wasn't, that it's supported enough that it's not going to produce an unfair result. And that's what the rules can't do yet. Now, they did come up with a proposed rule 901C. And in this particular instance, it would not necessarily be a notice issue, although for practice pointers, judges can do a lot to front these issues in their cases, to inquire to see if we're going to have this evidence so that we know. But remember, in this particular instance, you're not saying it's AI generated. So if there's a rule that I have that you have to tell me if you're going to offer AI generated evidence, you're saying it's not. This is just Grimm's voicemail. Right. I'm the one that has to raise that. And so there may be, you have to have, if you're going to contend that something was a deepfake, a fictitious or synthetic evidence created by generative AI, and challenge it on that basis, you have to give notice, and you have to come up with facts that are sufficient that a reasonable jury could conclude that it was. Then you would have the judge being able to say, what do you got to counter that? What's your evidence that it is? And then start to do that balancing test. And the balancing test that I would recommend is a balancing test that's buried in Rule 609A1 capital B, which is the 609 is the impeachment rule based upon a conviction. And Rule 609A1 capital B says that if a defendant in a criminal case is going to testify and may be subject to impeachment by their prior felony conviction, that the conviction can only be used to impeach if its probative value is greater than its prejudice. Now, that sounds like 403, but it's not. 403 is probative value must be substantially outweighed by the danger of unfair evidence. Each step makes it harder and harder to exclude. The 609A1 capital B is you balance it like that, and if it's slightly more prejudicial, you say it's out. And that should be done by the judge beforehand. And I trust judges, even though we're no better than anyone else in sort of understanding really high-powered technology, I trust their stomachs in terms about whether this is a little bit, there's something about this evidence I'm not sure of. I would trust that right now in the absence of some technological solution that can tell us definitively or better than that whether it comes in. And that's how it should happen. It should be that someone who has going to challenge this based upon it being fabricated should have to give notice of that at some point before trial. The judges can figure out when and make a sufficient showing to allow us to do that balancing before it goes to the jury.
Well, quickly, before we get to Rose's next question, how does that look when it's, say, an altered video or photograph? I mean, how does that analysis look? Do experts come to play, or how do you deal with that?
Well, that's the worry we all have. The worry that everybody has is that, we already have an access to justice problem. It's particularly bad in the criminal system. It could be bad in the civil system as well when so many pro se litigants have to be involved. But how are you going to tell whether it's fake or not? It's going to be hard without some kind of technical evidence. And so I think that we will be facing challenges associated with how do we do that. People say, well, we will use our good friend Rule 706, the court expert. But I don't know many judges who think that that's an effective tool, because it's great that we have a rule that says that these people can exist, but we don't have any appropriations to pay for it. And the notion of every time someone says it's a deep fake that you got to come in with experts, the requirement would be, as a challenger would still have to come up with sufficient evidence to convince the judge that a reasonable jury could find more likely than not that it was a fake. And if it's a video or an audio and you don't have some ability just by listening to it, or, it used to be the cadence was a little bit robotic, that's gone now. Yeah. The breathing wasn't in there, now the breathing's added. So you may have a situation where it's going to take some technical expertise in order to do it. But you've got to have someone's got to have the burden. And when one side says this is not AI generated and the other side says it does, you have to own that objection and be prepared to come up with what it is. It wouldn't necessarily have to be technical if there were other tells, but it's getting so good that those tells are all being addressed.
Yeah, I guess that's the liar's dividend where you can just. But
right.
Rose, why don't you?
Well, and I think from my perspective, so normally, if there is a challenge over the authenticity of some type of ESI, we would go back to the metadata, right? But now, even the metadata can be altered. So what other alternative types of evidence can counsel bring to the court?
So what is happening now is there are a lot of science folks in the computer science area that are looking about how to embed like a watermark kind of a thing in the genuine one. And there's some things that are promising. The problem is that these there are these things called GANs, generative adversarial networks, and so you have two computers that are competing, and one computer comes up with says, give us this, and it'll say that's a fake. So then the computer that's generating it says, okay, that's a fake. I'll tweak it here, and it keeps going back and forth until all of a sudden you can't tell the fake from the real. So yes, you can have a technological fix that can be embedded. There are various ways of trying to be done on that. But then you have to have them implemented. It has to be done widely. All of the platform producers that are used have to agree to do it, because if you only have partial, then it's not a sufficient solution to what it is. So it really is a challenge.
So I've heard you talk about a three-step triage for a judge to take when he or she is presented with allegations of altered evidence. Can you talk a little bit more about that?
The first things, I mean, one of the things that, and I think predominantly we're talking about civil cases here. In criminal law, there are the same evidentiary challenges, but the discovery process is completely different in the criminal system than it is in the civil system. It's much more constitutional or statutory obligated, because in theory, you don't have the broad discovery in the criminal system that you do, but you have obligations on the part of the government to disclose information, and certain discovery obligations on other things like experts and other types of information. So we're really talking about the civil system. And under the federal system, the one thing that all the ESI audience knows, meet and confer, Rule 16, the notion of the preparation and the collaboration that is ideally supposed to take place. And the judges that we saw yesterday, they're the ones that do this. They're the ones that live with this, and they embody it, thank goodness. But where the judge is active, you got the case from the beginning, you're going to have it through the end, you get them on the phone and you say, all right, I want to talk about two kinds of things in this case. Number one is if we have AI evidence that one side plans to introduce, I want disclosure of that. I want to talk about what discovery is necessary to decide whether it's valid and reliable, whether it's going to be challenged, and what we have to do to schedule a hearing to resolve that so it doesn't blow up in the middle of a trial. That's acknowledged AI. And I want to know that if there is going to be evidence introduced here that one side says I'm going to object to because I say it's fabricated, it's a hallucination, it's a deep fake, it's whatever it may be, I want that to be identified early, and I want this procedure to be followed. If you're going to challenge it, you have a deadline to say you're going to challenge it. Now, obviously, it assumes discovery that you got all the information, not something sprung on you at the last minute. And then we're going to have a process, and you're going to have to show me why, more likely than not, there is a basis under which a jury could find that it was not authentic. So you have the number one, the judge raises it to begin with. Number two, the lawyers have a disclosure obligation. And that's going to assume, and we were talking yesterday about lawyers not knowing that a case that they could have checked was a hallucinated case, not doing it. But how are you going to know? And remember, we had this in the ESI system, 15 years ago, where the client gives you what it was, and you didn't inquire, and it turns out that they had doctored something. Well, you're going to have those same kinds of issues where you might not know, but it's going to mean that the lawyers have a duty to inquire. It's going to be hard because even in a criminal case, you got all these law enforcement agencies. They all use different types of technology. The prosecutor gets it. They don't know all about how you capture it. They're just said, here's the evidence that we got. So the lawyers are going to have to be good about grilling their clients If this came up, how did you get it? How will we know? Is there metadata? If the judge says there's a challenge on this, what are we going to do to show that this is not fabricated evidence? And that means that the lawyers will have to be aware of that. The judge can tell them what their expectations are. Then you have the disclosure and the discovery process. Then you have the notification process, which may then itself lead to discovery, which then you lead to the hearing. Then the judge schedules the ruling on this and in a time to have it as far in advance of the trial as possible, and then you go from there. The key is that, you know, you may say, well, my God, you know, you have digital information in all cases. Are we going to have to go through this all cases? No, because the evidence that's really going to focus the attention is the blockbuster evidence. Right. And so you're going to know, you know, and if your gut says, oh God, this is terrible, I'm going to say it's a deep fake. That's not going to be enough. That's the liar's dividend. Yeah. You're going to have to come up with something more than that to create a real issue for the judge then to manage, the other side to have to address. And then the key to doing that is to try to do it in advance of the trial. And so you're going to have a lot more heads up ball in the planning and in the interrogation place where the judge exercises that Rule 16 and the pretrial management of the case on this type of evidence.
I mean, that's so smart because it's a twofold function. I mean, one function is you're looking out for the jury. You don't want them sitting out there while you're arguing over complicated things during the trial. But most importantly, it's a due process issue because you give both sides an opportunity, the one that wants to present the evidence and the one who wants to oppose it, an opportunity to argue that. So, Paul, this is great. If you're going to remember three things from this first part of our session, it's that now AI can be altered very easily. It can be altered by your client. It can be altered by basically anybody. It doesn't take an expert to do it, including images, video, audio, and metadata. And so you don't need that technical sophistication. Secondly, courts and counsel need structured and early management tools for disclosure, triage, and proportionality in dealing with these things, and to prevent the AI disputes from derailing the real case. And then third, judges have to deal with the rules that we have today, and those rules are a little complicated. And we had some very smart judges yesterday showing that they know these rules and that they have maybe even some differing opinions about them, but they're at least applying, because these are things that are going to shake out over a period of time, and there will be different opinions about them. But you're dealing with the rules we have today. Rose, why don't you take us into hallucinations now?
Okay, so if you follow me on LinkedIn, you know that I have been a bit obsessed with Charlatan's database, where he tracks the global hallucinations in citations and opinions or briefings around the world. And so every 3 months or so, I go in and I take a look and see the trends. The last time I checked, it's still trending at exponential growth, right? Which to me is really mind-blowing that we still continue to see the continual, filings of these briefs, but also, Judge Grimm, you mentioned this earlier, like someone who does it multiple times, like so one person not learning their lesson the first time. So from your perspective, what is a way that courts can help stop this from happening, but also not with like a chilling effect on the bar?
Yeah, I mean, I thought that the discussion yesterday was really terrific when we heard from the judges talking about sort of what the problem was. And, and there was the polling, and then there was the polling from the audience about how accountable they should be. And one of the things that we heard, and I think it still matters, is intentionality. Now, you got to be careful with intentionality, because there was a time, my friends in the audience and the judges yesterday were referring to that. But many of us who've been in the litigation business for a lot of years remember the challenges we had with Rule 11 when Rule 11 first came in. And then every time somebody filed something, it was, it's bad faith, Rule 11, I want sanctions. And there came what was known as the empty head, pure heart defense. I'm a happy idiot. I would never do that to hurt him on purpose, but I just didn't know. And so you don't want to reward that sort of weaponized ignorance. So you can't, it's not enough just to say, gosh, I didn't know. So there's a level of diligence that's got to be presumed. But I think that the key in looking at the use of a hallucination is that it is remarkable to me now that we're struggling to get across the finish line, Rose, in the easiest thing it is to check. It is, I mean, it's not like, is this a hallucination or not? Gosh, it's so good. I don't have 6 fingers to give me a clue. How can you know? This is like, I didn't look at the case to see if it was a real case that said what I said it said. And there's, like you're an engineer, engineers know that there's an answer and you can find it. You might have to do a little bit of work, but it is findable. This is a self-inflicted wound. And it's astonishing to me that with all the, the feedback that you hear, that it's still happening. I think you got to look at and this is what the judges said yesterday, I completely agree. You got to look at the facts and circumstances. Who did it? You've got to look at where in the food chain, in the legal ecosphere it happened. What you have to have is you can no longer have the total hands off from the top level people on the list of lawyers in the case saying, I don't do discovery, you guys figure that out and then bring it to me and I'll go into court and do what I do. You're all responsible. You got to set the stage. You got to make sure that the people who are providing the input, whether they're an intern, a law clerk, or a junior associate, knows this is what, if you're going to use this, you got to tell me. If it's, we have certain parameters. We heard about certain organizations having a culture right now where they say you can't use it for this, but you can use it for this, or this, you can use it for these ways of doing it. And then you make that clear. And then everybody who comes in has to say, yes, I checked that information. When I was in the Army, I was in a unit in the Pentagon. There was this little brainiac unit of people that were working on administrative law. And there was a check system. When I, as the lowly captain, gave something to my lieutenant colonel, I had to give him a photocopy of all the cases I cited in my analysis. And then when I cited the case, I had to put a check above that citation, meaning I had gone into that case and looked at it and found that there and had correctly quoted it. He then had to duplicate my work and slash through the check with a different color pen. And that went all the way up until it got to the general. And I could tell you when it got to the general, it may have been a piece of garbage, but by golly, it was a well-checked piece of garbage. And so the thing is that that's all it takes here. And I don't know, I mean, I think we all have, we're all part of the problem if we're not part of the solution. Bill said this, and this is what the University of Florida is trying to do, and other schools are, I hope, following suit. We got to teach these students in law school, this is not something that you just do and you've got your earbuds in when the professor says this is the proper way of using AI and not. You got to be focusing on that. That's got to be instilled as an absolute professional rigor. Then you've got to have the people who are on the chain, if you have multiple people involved with it, all the way up to the top, who are enforcing that. And then, doing spot checks. It is easy enough with some of the tools we heard about yesterday, where I think that there's one in Westlaw has, where you can run a brief through it and it will tell you if there are any cases cited that are hallucinated cases. And it will also check the quote and give you the actual quote. If there's, even if it's something as simple as a grammatical or a semicolon in the wrong place, it will show that to you. So there are tools available to check it. So we have to have enough responsibility in those cases where it's warranted, where lawyers are saying, that was not pleasant. I think I would like to avoid that again. You've got to have the architecture within the firms that are going to follow through on that. And maybe what you do is, if you're going to whack somebody and you've got a young associate who tried and just relied on it, and you've got a grizzled old partner who says, I don't do security, I don't do discovery, maybe you whack the grizzled old partner and put the sanction there, and you double down on the supervision. But I share your astonishment that it's still growing when it's now this widely understood that this is beaucoup embarrassing, and in some instances can be really have be a non-career enhancing move.
I want to emphasize something that you mentioned. So I love the checks and balances, but I think what's really important is the mentorship and that we have in a supervisory role. And
Absolutely.
That is getting on the call and saying, did you use AI? And if you did, that's okay, right? Like maybe we're encouraging at our firm, but did you use it? Let's talk through what you did to ensure that the citations are accurate, that the cases are real. And so I do think that we, as the supervising partners, we have an obligation to have those conversations with the younger lawyers and help them leverage the tools in a way that is to the best of their ability, right? And the best use for our clients.
Rose, this is an important part. When I talk to lawyers now, and I have, my wife and I have a daughter who's a lawyer and a son who's a lawyer, and they're both in private practice, and I see it in their lives. I mean, Ralph, we had this conversation. Ralph and I, we've gone beyond that place. You know, like a 59-year-old person dies of a heart attack, and they say, "Oh, it's a terrible thing. It's 59." 60-year-old person dies, and they say, "What'd you expect? He was 60 years old." And we've crossed this. I have a T-shirt at home that my son gave me that says, "I survived the 60s twice." So I'm of a certain age, and you are as well. We thought we were busy when we were coming up in the law. I thought I was really busy, but today these young lawyers at all levels, they are overwhelmed. And I talk to people even in corporate law, the days of a nice, we come in at 10, we have a 3-hour lunch and then we go for cocktails at 4. That's not happening in any place that I recognize. It is do more with less. The pressure is intense. And so what has sacrificed is that mentorship. Come with me to the hearing and listen. Now let's talk about that. You talked about how when you were first starting out that you had a mentor that would talk to you at the end of the week about everything you did that week as a lawyer. You would go through it and dissect it. And then he would say to you, now what do you think about that? Had the actual interest in your development to ask you that. That is less and less happening. And so everything is siloed to where, the junior associate speaks to the next level of junior associate and then the intermediate associate. And there are these firewalls between them rather than links between them. And I think that we have lost a lot where I hear lawyers say, look, I wish I had time to mentor, but I don't. And I try to say, you don't have time not to mentor, but that's like, when a cat hears a person talk, the person saying, why did you do this, that, and the other thing? And the cat hears, question mark, exclamation point, asterisk, is looking at him like, is there words coming out of your mouth? What are you talking about? They just is water off their back. I don't have time for that mentorship. I don't even have time for my family. What am I supposed to do? And that's a real challenge because when you are hurrying in an environment where you're putting things out there that are so important and the consequences, if they're wrong, are so disproportionate to the effort it would take to fix it, we just got to figure out a way to try to address that more. Maybe there will be some technical tools that we can at least do that, run it through that will test it. And you can say that that's one level of diligence that I did. But boy, you would think that by now that there would be some progress there.
Well, we're now seeing actually in judicial opinions, hallucinated cases. So, I mean, if you were, we have a question.
Yeah. Yes.
Judge Grimm, this is, Manfred Gabriel. My question is, how do we enforce discipline around hallucinations, like citing the case law properly, confirming that it is, without penalizing the clients of the attorneys that are being represented, right? Because we've seen this with shoddy lawyers' work representation in the past, where local rules aren't being obeyed, formatting rules and so forth. And the tension is always that you don't want to punish the client who may have a good case for the failures of the lawyer.
Well, so the question is a good question. We don't want to punish the client. You have a lawyer that doesn't do something that they should do. There's only so far you can go to insulate the client from the error of the lawyer. And if it's a financial costs, you can fix that. You can say, the lawyer is sanctioned. It comes out of the lawyer's pocket, not the client's pocket. So you can work on that without too much difficulty. But if it's the kind of thing that has a very significant, because remember also that you got two clients. You got an adversary system. So on one side, you got a client whose lawyer didn't do it, and that had an impact on the client who's been impacted by that mistake. And at some point, just like the principal can be implicated by the action of the agent, at some point it's got to be passed on to the client. And one of the things that is happening is that clients are getting more sophisticated in saying, and this is part of a problem too, is because some clients are coming to the lawyers saying, you must use AI, because I'm not paying you 7 hours worth of time to do X if you can do it in an hour's time with AI. And that's when that dialogue's got to be, but we could have these problems come up and you have to have communication with your client. So judges will always try not to penalize the client for the sins of the lawyer as long as it does not put the burden unfairly on the other side that had the consequence of that. And, in the extreme case, if it's a bad outcome for the client, it's like other areas of professional work where a bad outcome has a consequence down the line, as the medical profession has found. At some point, you can't avoid that. And that's why the lawyers really need to clean up their act on their own beforehand so it doesn't get to that point.
Yeah. One other point I really want to chat about before we wrap up. This has been excellent. Thank you so much. How can we help each other out as lawyers, right? So if I spot one, I'm going to pick up the phone probably and call my opposing counsel and say, hey, I found this, should we meet and confer, and how can we resolve this and help each other out? What's your position on that?
Yeah, I think that I in a lot of different contexts, but in this context as well, we have to remember that we are not just a business in the law, that we are a profession. And with that profession comes obligation. And so long as it's not to the detriment of your client, the notion of going to the other side, and look, it's got to be shaped by the experiences with the other side. If you know the other side is a decent lawyer or someone who's not trying to intentionally do this or may just be unaware of it, then it is, what is better? Is it better to go to them and say, hey, I think this is a problem, you may want to reconsider. Let's say they change it, and now you don't charge your client for a motion that you have to file. They have a response, you now have a reply, you now have a hearing, a judge has got a rule. So that's smart, that's smart way of doing it, because it's consistent with your client's objectives, but it's also professionally there. The other thing too is what goes around comes around. Mm-hmm. And if you're the reputation of the one who is, triumphant, well, let's hold off on it and I'm going to expose that in a big motion and say sanctions and all this stuff, then the consequence of that is that the word gets out pretty quick, and you better make sure that you're not in a situation with the shoes on the other foot.
Paul, thank you so much. I mean, if we're going to remember 3 things from the second session, AI hallucinations are not just citation errors. They can affect the facts and analysis and reasoning, and they always remain the responsibility of the human who submitted them. Secondly, judicial responses should be measured and proportional, distinguishing between mistake, negligence, and bad faith so that sanctions deter misconduct without discouraging responsible use. And third, that banning AI is not the answer, because it's still going to be out there. People are going to use it, so that's not an answer. And I do want to say one other thing, Bill. I know we're at the end. We are not anti-AI. We've been talking about dangers from AI today. I mean, we all realize that it's here and we're going to use it, and it has so many beneficial uses. So don't get the idea that we're just here to make AI look bad, because we're here to make lawyers look better. So,
yeah, okay. I like that.
Yeah.